I'm Kathi Vidal. From shaping AI policy for the Biden administration to working on global innovation policy, I have heard from numerous companies on AI. We know that AI holds the potential to democratize innovation and to solve community and world problems. But we also know we need to mitigate the risks. I'm here today with Sara Susnjar, my regulatory partner based in Paris, France. She's a member of our firm's AI committee, focusing on compliance and regulatory enforcement, which includes data privacy, digital assets, and AI. We've been having a number of discussions about the regulatory scheme in the United States and in Europe and across the globe. Today, I want to focus a little bit more on the EU, since Sara is in Paris. What are you seeing, Sara, when it comes to the regulatory landscape?
Well, thank you so much for that great introduction, Kathi. We've been living with AI for the past 30, 35, 40 years. It's only in the past year and a half that we've been talking about it. And sometimes we've been using the term correctly, sometimes we've been misusing the term. But for the most part, in the EU, what we've been seeing is the EU AI Act. The EU AI Act entered into force in August 2024. It is a gradual enforcement mechanism, meaning that it's going to be fully implemented by August 2026, with the very first steps that came into effect only a month ago in February 2024. And it really targets companies that are operating or companies that are targeting the EU. And the way that it works with the AI Act is that it classifies systems on the basis of risk. There's 4 different classifications. There's the unacceptable, prohibited classification, so AI systems that are prohibited. And that's the first phase that came into effect in February 2024. So what's prohibited is prohibited, and those AI systems cannot be on the market. Then there's a high-risk category, so systems that are high risk. After that, we have limited risk. And finally, we have minimal risk. What's really interesting about the EU is that as soon as the unacceptable risk category of systems had come into effect, the EC, they released the guidelines in February of this year to state, what is unacceptable, what is acceptable. And these sort of non-binding guidelines are important because they guide courts, they guide regulatory bodies, they guide member states on their enforcement, and also on some of the jurisprudence. And so that's what we're seeing in theory, I say. What we're seeing in reality is a bit more complex. There's a lot of questions when it comes to the EU AI Act. There's questions as to whether AI systems are too broadly defined so that they cannot be actually applied in real life. I would say originalism versus evolution debate. Will the AI Act stand the test of time? We know that AI is advancing quickly, rapidly. Is this act going to be valid in a year or 2 years? Is it going to be a mechanism or a regulation that's going to be able to stand the test of time in light of the speed of evolution with the AI systems? And most importantly, I think I would say that there are questions as to the politics of it. We're living in a global environment. We're looking at an environment that's treating AI systems differently. The US is definitely treating things differently. China is treating things differently. And the EU, with this AI Act, will it work in the ecosystem that it exists in?
Interesting. So you mentioned products that were banned in February. Can you go through some of those products?
Yeah, so basically the AI Act talks about systems. In some cases it talks about models, but systems that are basically to be too dangerous to be out in the market. I don't want to kind of date ourselves, but if you think about the movie Minority Report with Tom Cruise that came out in 2002, Tom Cruise was an agent and there was an AI system there that was predicting people who would commit crimes before the crime actually happened. So I guess we can think along the lines of something to that extent, that we prohibited this kind of predictive behavior. Social scoring systems are prohibited under this category of unacceptable risk. Untargeted scrapping from websites, biometric information, and in order to have a database of facial recognition, that is also prohibited. Emotional recognition in the workplace or in education, that is also prohibited. And also real-time law enforcement tools, things that basically put into question the public space and where there's monitoring of these kinds of biometric, I would say, facial recognition by the police. These kinds of models are definitely considered to be unacceptable.
And what about the other categories that you talked about? Can you break those down for us?
Sure. So when it comes to high-risk systems that go under strict scrutiny, these are systems that are critical infrastructure, healthcare diagnostics, AI, robotics in surgery. So these will be regulated, heavily regulated under the EU AI Act. When it comes to limited risk is pretty easy. You just have to disclose what exactly your system is. And these are like chatbots on a website. You go on a website, there's a chatbot, and so you disclose, well, we're using an AI system. And then minimal risk, it's things like, I would say, spam filters. It is also AI in video games. And those are considered to be very minimal or low risk. Now, they say that 95% of the systems that we're going to look at are going to be either low risk or minimal risk. But I can tell you in the past year and a half, everything that's come across my table has been in the top two categories: my high risk system, my unacceptable risk system, how am I gonna use it and put it out into the EU market. So I've been seeing questions more on that end versus the 95% that's supposed to be low risk.
Well, it makes sense, right? That's when you call your lawyer. Let's talk about enforcement. Who's going to enforce this in the EU?
Well, I think you should do it. For the time being, the way that it's organized is there's an EU office, an EU AI office that's going to coordinate enforcement across the member states. So there's going to be EU AI office on an EU level, and then there's going to be a member state level where the member states are going to choose their own authorities or authority, depending on the structure, that are going to enforce it on that level. The one thing to point out is that even though certain parts of the AI Act have come into effect, especially as we talk about high risk and prohibited AI, the fines and the actual scrutiny is not going to come in until about August of this year. And a lot of the member states have not even set up the proper authorities that are going to handle these kinds of cases. So we're really in the beginning steps of it. It's also why there's so many questions about how things are going to work and whether or not this is going to be a large liability.
Well, and I know that you deal with compliance on a daily basis, and you're assisting clients. What kind of questions are you getting from clients, and what issues are you dealing with?
So the first question I'm getting is, how do I make this go away?
Good luck.
We don't want to, fall under EU AI Act. We are not going to operate in the EU, and we're not going to target the EU. So it's not going to, it's not going to work for us. And maybe that's something we can discuss in regards to extraterritoriality. But that's the first question I'm getting. I don't want it to, we don't want it to work. So then they come to terms with, okay, maybe we're going to have to at least analyze it. And we talk about, at least here at Winston, we talk about AIM, is that we assess it, we implement, and then we monitor. And so we carry out an assessment of, okay, where does your system, where does your model fall in the scale of things? And the questions actually are in regards to the classification, even though, we gave you sort of we call it a Cliff's Notes version of how AI systems between the high risk, between the no risk categories, how they fall into place, the actual application part is quite difficult. Because you might have a system with certain nuances, certain flavors, and it's hard to classify it. And the guidelines they come from the European Commission, but they come kind of after the fact. We've gotten certain guidelines, but not that many. And until there are actually more guidelines in place and there's actually case law, it's actually quite hard to identify some of the systems and where they fall into place. The other thing is the awareness of risk. What we should highlight is that companies that do not comply with the AI Act in the EU, they can be fined up to 35 million or 7% of the global annual turnover, which to me means anywhere between $1 to unlimited, right? Because these can be very, very high fines. And sort of assessing the risk of those fines is very, very important for clients. Which brings me to my last thing, my last point. Clients often ask, well, what about the Form 10K? Do I list the EU AI Act as a liability for my company? And that's for public companies, obviously, but in some cases, even non-public companies would need to disclose in some of their financial documentation. Do I list it as a liability? And the answer is, well, if it is a huge liability for your compliance, a cost compliance, if the penalties could really significantly impact you, and if you really believe that there is an inconsistency in the application, then list it. And so we've advised a lot of the companies that have come to us to actually list it in their Form 10K.
That's interesting. So you mentioned extraterritoriality.
Yeah.
Now that I'm also doing AI privacy work in addition to IP, a number of clients have told me, well, I'm just not going to operate in the EU. I won't market there. I won't sell there. What advice are you giving people?
I would say this. EU AI Act comes as a part of a long line of extraterritorial regulations that have come either from the US or from the EU. We know that GDPR, which is the data protection regulation in the EU, has extraterritorial reach. We know that in the EU, there's extraterritorial reach with certain competitive practices, and antitrust. And so the question becomes, okay, are you a company that's developing, a company that's operating and targeting the EU? If the answer to any of those is yes, obviously the EU AI Act is going to apply. So the way that it works is that if you are a company that's either operating in the EU or targeting the EU, as Kathi pointed out, the EU AI Act would apply. But let's say that you are not targeting the EU. Let's say you're not operating the EU. But if you provide any kind of AI systems in the EU, even if you're not targeting, even if you're not operating, but there's some kind of provision, the EU AI Act would apply. Now, let's say that you have users of your AI system in the EU. Well, then again, it would apply even if you're not targeting and even if you're not operating. But let's go to the worst case, I guess. So let's say you're not providing, you don't have users in the EU, but let's say that your AI system has an impact on EU residents, kind of like GDPR, right? There's an extraterritorial element and the EU AI Act can apply. Now, one thing to point out is that there's numerous tests that, in the EU and the jurisprudence that we've seen in the case law, they analyze whether, there is an impact, for companies that don't have a presence and don't actually have systems in the EU. For the most part, there's some debate as to what test will be used, but I think the common one, the one that deals with the imminency, the one that deals with the substantial and the foreseeable effect. So do you have an imminent, substantial, and a foreseeable effect, even though you're not present in the EU, even if you don't have systems in the EU? To that extent, the EU AI Act could apply. And as we mentioned earlier, when there is a different approach to regulation, whether it's in the US or whether it's in the EU, these extraterritorial acts become a tool to see which side is stronger.
It's interesting because I know that there's some political tension right now between the US and Europe. Do you think that that's going to be impacting companies from the United States?
I think that's a good question, actually. I think it's going to be impacting companies from the United States because they're asking the question, a lot of our clients, come from the US. I don't want the EU AI Act to apply. And as a result of that, I don't want to have, systems or models in the EU. So to that extent, I think that it is going to impact at least their strategy, their marketing strategy, and their development strategy. But I also think that regardless of that, it's going to be almost impossible to ignore the EU AI Act unless, something unexpected happens. And I do think that there's going to be fines. And I do think that there's going to be targeting of big tech companies in the US because that's where the pockets are deep.
That makes sense. I know that my clients are saying it's not about will you be fined, it's about how much you'll be fined. And so they're trying to minimize the fines.
We deal with risk, we assess risk, and we have to live with the risk that we have. And so our advice to clients is not necessarily, you can't do that, you shouldn't be doing that. It's more, well, let's see how we can drive, how we can surf in the waves that we have.
Well put, well put. Let's talk about data privacy. So you've worked in data privacy for quite a while. You work with 40 of our other colleagues on that. What do you see as the intersection of data privacy and AI?
In some ways, the two coexist. For example, when it comes to data privacy, GDPR definitely has an impact on AI. We've seen it at least in what we're doing today because a lot of the DPIAs, the data privacy impact assessments, the DPAs, they include AI as a preliminary step to getting these systems out into the market in the EU. In GDPR, you have user consent. You have data minimization. You have the right to be forgotten, the right to be explained, which is a part of the AI systems that deal with a lot of personal data and that are constantly collecting this personal data. So you have to sort of have checks in mind and considerations when you're with the fact that the GDPR does exist. But there's also conflict. And the conflict comes in, GDPR is about minimizing and protecting the rights of personal data and personal information that's out there. Whereas when it comes to the AI and AI systems, they feed data. They feed data, they get trained on data, and they want as much as possible. So there's a direct conflict between the minimization aspects of GDPR and the necessity to evolve, the necessity to be fed with the AI system. And so the second thing is that when it comes to GDPR, we know that it's against automated decision making. GDPR doesn't like it, right? However, the EU AI Act, the automated decision making is a part of it. And so it does not define, the EU AI Act does not define specific rights against automated decision making, whereas GDPR does. So these kinds of conflicts in two regulations that work in parallel and often treat the same types of systems and the same type of personal data, this is where the conflict does come in.
So, Sara, we've talked a lot about Europe, and I know when you give advice to clients, it's not just on Europe, it's the whole landscape across the globe. What are you seeing outside of Europe?
The two debates are, which approach are we going to apply when it comes to AI? Is it going to be the regulated approach, or is it going to be the innovated approach? And when it comes to that, it's a story as old as time, right? Innovation versus regulation. How do the two balance out? In the EU, with the EU AI Act, they have accepted, or they have at least taken on the more regulated approach. But when it comes to the rest of the world, and more specifically the US, there has been a more innovative approach. We know that President Trump has revoked President Biden's AI order. We know that not even a month ago, there was a large AI Action Summit in Paris. And during the AI Action Summit in Paris, there was a statement on inclusive and sustainable AI practices that was signed by 60 countries, including India, France, China, but the UK and the US have not signed it. And so this is where I'm saying the more innovative approach, because the US has stated that they want less regulation. More specifically, was Vice President J.D. Vance has stated that, they didn't want to sign the statement because it's too regulated. The UK have stated that it's not practical enough. When it's not practical when it comes to security, it's not practical enough in its application, and so they refuse to sign it. So those kinds of approaches and debates are seen across the globe. Now in the US, the way that they're going to have to deal with it is either on a federal level, and if on the federal level there's nothing that comes out, it's going to come out on state level. And you'll see things, California kind of leading the way, the same way that they have with data privacy and putting in place certain laws that would, I guess, to some extent regulate AI. You see New York doing the same thing. And so some might say, well, it's very much like the EU. There's, the EU level and the member state level. And I would say, but not exactly, because the relationship between the states and the federal government are actually quite different. And if there is nothing on a federal level that comes about in the US, it'll come about in the state level. But we work quite a bit with our US colleagues, with you as well, when it comes to the AI applications here in the US, and we do it quite seamlessly, as a one firm.
So let's have you read the tea leaves here for all the counsel on the line. What do you see as the future of AI governance?
I think that there is going to be the battle between innovation and regulation, and they're going to have to strike a balance, whether it is through jurisprudence, as we say in Europe, in civil law systems, or case law, as we say in the common law systems in the U.S. I think there is one way to do it. I think the second thing is going to be political elements. I think the extraterritoriality aspect of the EU AI Act is something that we don't talk enough about. I think that there are going to be fines, at least starting in August of this year, for violations of the act, and it's going to be to some extent a political tool because it's an easy one.
So where can clients go to learn more?
So for resources, I would do three things. First, I would start with our Winston website. Our Winston website has a very comprehensive data privacy AI section, including our blog. I would also include the Sedona website, which also is very comprehensive on privacy and AI and very much up to date. The European Commission website, and third, say the IAPP.
Well, I'm Kathi Vidal here with Sara Susnjar, and just appreciate the time today.
Thank you so much, Kathi. It was great to see you here in LA.
Thank you.